Former Eskom CEO Brian Molefe has launched an urgent court bid to have the decision to remove him as Eskom CEO declared invalid. He has served papers on both the Power Utility and Public Enterprises Minister Lynn Brown. The minister's office indeed received the papers and confirmed that her legal team is studying the documents. Molefe's return to his Eskom CEO position on May 2nd after 3 months serving as a Member of Parliament was rescinded by the Power Utilities Board. Ben Ngubane, chairperson of Eskom's board, said that this was in line with Brown's instruction on the 31st of May. In his court papers, Brian Molefe is arguing that his dismissal was unlawful and unfair. He says in his papers that only the minister and not the Eskom board have the power to remove him as Group CEO, as per Clause 14.3.4 of the Memorandum of Incorporation. He further argues that his dismissal was required to be effected in terms of Section 186(1)(a) of the Labour Relations Act and that a summary dismissal cannot be imposed on him. He also says that there is no legal basis for his dismissal premised on his conduct, capacity or operational requirements. Molefe further argues that his dismissal by Minister Brown was motivated by political considerations which do not amount to lawful grounds. And finally, he says that in entering the reinstatement agreement, Eskom elected to honour his March 2016 contract of employment and in so doing divested itself of any right to dismiss him.
The papers and our legal team is busy then pouring over those so that they can derive our own response. So that is essentially going to be the case that then in terms of the challenge, we need to actually find a way of responding to that. That's what we are busy with. Right now, we are working, in tandem with, the Labour Court to make sure that we deposit our response in time, relative to whatever could be the timetable in that.
The law is on his side. The best way was for him to have approached the courts to ask them to interpret what the legal provisions are and what powers, the African National Congress would have had to instruct the minister to rescind an appointment when the minister does not even enjoy the legal privilege to have instructed the board of Eskom to do what it did. And therefore, these are operational matters, and it was not their legal privilege to interfere or intervene, for it is unlawful. Why they even thought that they could do it, it is baffling, said to say that it only confirms the Democratic Alliance's long-standing accusation.